Thanks for tuning in to your daily dose of quick real estate updates, local housing trends, and market data, plus tips, tools, and strategies to help you buy, rent, or invest with confidence. You're now getting ready with RealiCare Reports, powered by the innovation team, Cami and Rex. Now go grab your favorite morning beverage, whether that's coffee or tea, and let's enjoy this episode.
Ever wondered what actually happens, behind the scenes when you hand over a rental application in Florida? It feels a bit like a black box sometimes.
Yeah, it really can.
So today, we're going to try and crack that box open. We've got this article here that really digs into Florida rental applications, what info landlords are collecting, and maybe more importantly, the rules they need to follow.
Right. And our mission basically is to pull out all the crucial stuff for you. So by the end of this deep dive, you should feel a lot clearer on what to expect when you're applying for a rental in Florida and what your rights actually are.
Exactly. Because you're giving them a lot, right? Your rental history, any criminal background stuff, your credit score.
It's a ton of personal information.
Yeah. And while landlords do have some leeway, there are definite lines they can't cross, specific guidelines around those checks.
That's a really important point. Florida law tries to balance things. Landlords can, say, set their own application fees, but you, as the applicant, have real legal protections too.
Okay, let's start right there then, with those application fees. If you're trying to rent in Florida, what's the deal? How much can they charge just to look at your application?
Well, this is where it gets interesting. Florida state law. It actually doesn't put any cap on application fees.
Really? No limit at all?
Yep. Landlords can pretty much set the fee at whatever level they decide, which, in hot rental markets could mean things get pricey just applying.
Wow. Yeah, that could add up fast if you're applying for multiple places. So theoretically, a landlord could charge massive fee.
Theoretically, yes. But the article we're looking at does point out a recommendation. The idea is that landlords should try to keep fees reasonable, sort of covering their average out-of-pocket costs for running the checks and processing things.
Okay.
Not really meant to be a profit center, more about recouping actual expenses.
That makes a bit more sense, I suppose. Okay, moving on from the application itself. What about security deposits? Once you're approved, are there rules there?
At the state level, it's similar. Florida doesn't set a statewide limit on security deposit amounts.
Same deal.
Pretty much. But, and this is important, individual cities or counties might have their own rules. So it's always a good idea to just, do a quick check on local ordinances wherever you're looking to rent.
Good call. Definitely worth checking locally.
Oh,
All right, let's get into the core of it. What are landlords really looking at? What are those big factors when they decide yes or no?
okay. So number one is usually your credit history. They'll want to run a credit check or get a full credit report.
Right.
But here's the key thing. They absolutely must get your written consent first.
Okay. So you have to sign off on that specifically.
Yes. No consent, no credit check, period. And the article makes a distinction too. Sometimes it's just a basic pass-fail check. Other times it's a full report.
What's the difference there?
Well, the full report often gives more detail, like maybe employment history, income verification. It gives the landlord a much broader financial picture.
I see. Okay. Credit check needs consent. What about, your history as a tenant? Evictions and things like that.
Oh yeah, they can definitely look into that. Landlords in Florida can access your eviction history. And that includes not just final judgments, but also any eviction filings against you.
Filings, too, even if you weren't actually evicted.
Correct. For the past 7 years. The article even mentions how they can do it manually, go onto Florida's court docket search website, and look you up by name.
Wow, okay. And do they need your permission for that check?
No, and that's a crucial difference. Unlike the credit check, they do not need your consent to look up eviction records. That's considered public information.
Gotcha. Public record, no consent needed. Okay, what's next? Criminal history, that's often on the application, too.
Yep, criminal history check is another common one. That report basically shows if you've been involved in state criminal court cases or if your name pops up in certain related databases.
And let me guess, no consent needed for that either.
You got it. Same as eviction records, no consent legally required in Florida for a landlord to check your criminal background.
Okay, so let's just recap the consent rules because this seems important.
Definitely. So the Federal Credit Reporting Act, that's FCRA, mandates your written consent, specifically for credit checks.
Right.
That consent might be on a separate form or it could just be a part of the main rental application you sign.
Okay.
But for eviction history and criminal background checks in Florida, no consent needed from you.
That's crystal clear. Super helpful to know. Now, let's flip it. Are there things landlords absolutely cannot consider? Things that are off limits?
Yes, absolutely. And this is federal law, the Fair Housing Act. It's huge. It protects people from discrimination in housing.
Okay, what groups does that cover?
Landlords cannot discriminate based on color, nationality or national origin, race, religion, familial status, meaning like having kids, sex, or physical or mental disability.
So basically, they can't make a decision because of any of those things?
Exactly. And generally, they shouldn't even be asking about them on the application. That's usually illegal too.
Seems pretty straightforward. But I remember the article mentioned a few, like, really specific exceptions.
Yeah, there's some very narrow ones. For example, a religious organization renting out non-commercial housing might be allowed to give preference to people of the same religion.
Okay.
And age discrimination is okay only in specific age-restricted communities like designated senior housing.
Right, like a 55-plus community.
Exactly. Then there's this thing called the Mrs. Murphy exemption.
Yeah, what's that about? Sounds kind of old-fashioned.
It is a bit dated terminology.
Yeah.
It basically applies to owner-occupied buildings with 4 or fewer units. So if the landlord lives in one of the units in a small building like that, some fair housing rules might apply slightly differently. And this is critical discrimination based on race is never allowed. No exceptions for race.
Okay, that's a really vital point. Race is always protected. And private clubs, was that another one?
Yeah, another narrow one. Private clubs that provide non-commercial lodging, aren't open to the public, and don't discriminate among their members might have some leeway.
Yeah.
Again, these are really specific, limited exceptions.
So for the vast majority of rentals,
Landlords need to steer clear of basing decisions on any of those protected characteristics. It's the safest and, frankly, the legal way to operate.
makes sense. So if you're applying and see questions about, say, your religion or if you have kids, that's a red flag.
Definitely a red flag.
Okay, let's loop back to those eviction records for a second. You said landlords can check them manually online. How does that work?
Right. So the article points to the Florida Supreme Court docket search. A landlord can go on that site, choose the option to search by party or attorney, type in the applicant's name, and if they know the county, they can filter by that too. Then they'll see a list of cases, and they can click into them to see the details about any eviction filings or judgments.
So it's all out there, accessible. Okay. Now imagine a landlord runs all these checks, credit, eviction, criminal, and villas, and decides, nope, not renting to this person. Or maybe, okay, but I want higher rent, or you need a cosigner now. What happens then?
Right. This is where adverse action notices come in, and it's really important for applicants to understand this.
Adverse action.
Yeah, adverse action means any negative decision based on the info they found. So like you said, rejecting the application, charging higher rent than advertised, suddenly requiring a cosigner, asking for a bigger security deposit. All those count.
And if the landlord takes one of those actions because of something in, say, the credit report,
Then they have a legal obligation. If the decision was based even partly on information from a consumer report, which includes credit reports and often criminal and eviction reports from screening companies, they must give you an adverse action notice.
they have to tell you something went wrong. Do they have to say exactly what?
Interestingly, the law doesn't strictly require them to state the specific reason for rejection, though the article suggests it's good practice for them to do so.
Okay. But what must be in that notice they give you?
Okay, the notice absolutely has to include several things. First, it has to state that the landlord didn't make the decision based on their own info, but on the report from the agency.
Right.
Second, it must give you the name, address, and phone number of that consumer reporting agency, the company that provided the report.
So you know who generated the info.
Exactly.
Yeah.
Third, and this is key, the landlord has to give you a copy of the actual report they used.
Oh, you get to see the report yourself.
Yes. And finally, the notice has to inform you of your right to dispute the accuracy or completeness of any information in that report directly with the reporting agency. And you have 60 days to do that.
Wow. Okay. Getting a copy of the report and knowing you can dispute it within 60 days, that sounds like a really crucial protection for renters.
It absolutely is. It gives you a chance to see what the landlord saw and correct any errors that might have unfairly cost you the rental.
Definitely. Okay, the article finished up with a sort of FAQ section, hitting some key takeaways. What were the highlights there?
Yeah, just to quickly recap some practical points.
Yeah.
Application fees.
Yeah.
Average might be around $30, but remember, no legal maximum in Florida.
Right, no cap.
Credit scores.
Right.
It really varies. Depends on the market, the landlord.
Right.
Could be a minimum like 650, maybe lower like 590 if your income is solid. No single magic number.
Okay, depends on the situation. And the general requirements tenants usually need to meet.
Generally, yeah, landlords want proof of income that meets their criteria, a decent credit history, information on any criminal record, and of course that rental history check for past evictions.
Standard stuff, mostly.
Pretty standard screening criteria.
The article also touched on some tools landlords use, like online application forms, e-signatures. Anything applicants need to know about those?
Mainly just to be aware that technology is common now. You'll likely fill things out online, sign electronically using software like DoorLoop, which the article mentioned. These systems often link up with lifting sites and screening services like TransUnion.
So it makes the process faster for the landlord, basically.
Exactly. It streamlines things on their end. For you as an applicant, it just means expecting a more digital process, usually. Nothing too complicated, just, the way things are often done now.
Gotcha. So boiling it all down, navigating rental applications in Florida is really about understanding both sides, isn't it? Landlords can screen you, but you have rights.
That's the perfect way to put it. It's a two-way street. Remember that written consent for credit checks is vital, and know what an adverse action notice is and what rights you have if you receive one. That's probably the most empowering knowledge you can have.
Absolutely. This has been incredibly helpful, really clearing up what can be a pretty murky process. So to leave everyone with something to think about, here's a final question. Considering how much personal information landlords can access during this process, what do you think are the bigger implications for tenant privacy down the road, and maybe for the future of renting itself?
Well, that wraps up today's episode of RealiCare Reports, where real estate meets real life. For more updates, tools, and insights that will help you buy, rent, or invest with confidence, be sure to follow, subscribe, stay connected, stay informed, and stay ready. Until next time.